I'm very excited to hear from our speaker. This is the 2013 American Constitution Society Supreme Court Preview. As you may know, this is an annual event where ACS brings in speakers from around the country to talk about the upcoming Supreme Court term. Before I introduce our speaker, I'd like to thank the sponsors who have made this event possible today. The local sponsors for the event are Vasberry & Sims and Sherrard & Rowe, who are both gold-level sponsors, Hollins, Graven & Wiseman, Lee Bracer, who are silver sponsors, Bone McAllister, Mr. Harris Gilbert, and Trouter & Took, who are bronze sponsors, and also Mr. George Barrett. Also, special thanks to Vasberry & Sims for allowing us to use this fantastic space for the event today, and also for coordinating the box lunches that everybody's enjoying right now. So it's my pleasure to introduce our speaker today, renowned Supreme Court litigator Paul Smith. Paul is joining us from Washington, D.C., where he is a partner at the firm Jenner Block. He is the chair of several practice groups, including the Appellate and Supreme Court practice, the Media and First Amendment practice, and election law and redistricting practice. He's argued 14 cases before the U.S. Supreme Court, including the significant Warren v. Texas landmark gay rights case, and Brown v. Entertainment Merchants Association, the recent First Amendment video games case. Among his many accolades and distinctions, he was a law clerk to Justice Powell, is on the ACS National Board, and I also found it interesting on his firm bio that he is admitted to practice before all 13 of the federal courts of appeal. Our plan for today is Paul's going to speak for about 45 minutes to an hour, and then we'll have some time for question and answers. So, Paul.
Thanks, Ryan, and thank you all for being here. I'm really pleased to be here. I was telling some folks over there that this is my first time I've ever been in Nashville, so it's good for me. It's finally time that I come here. And I've also, I've only been here about 4 hours. People here are a lot friendlier than when I come here. Even like in the airport, all places. It's nice. Thank you all for being involved in one way or another with the American Constitution Society, which I've had the privilege of being involved with at the national level. I think it's an organization that's contributed a lot to the dialogue among lawyers about how to think about the Constitution and progressive values, and I think it's something we need to continue to support. But we're talking today about the Supreme Court in this coming term, which I think is hard to match the last two terms for blockbusters. So we had a term with the healthcare case, which was a blockbuster term all by itself, just because of that one case. And then last year we had affirmative action at stake, the Voting Rights Act, and the gay marriage cases. So the coming term may not quite measure up to those, but as I think I'll be able to convince you, there's a lot of really interesting and important cases, many of which are building on the cases that have just come before. It would appear to me that the conservative bloc at the Supreme Court is feeling like they want to take as many big controversial issues as they can, as fast as they can. It's not, partly I think there may be a sense in which their ascendancy is not permanent, that the politics of this country continue to move in the direction that they have been moving. They may not have 5 votes forever. It's also, I think, perhaps some instinct to push back against what they perceive as the more progressive people running the country and the other branches in Washington, or at least outside the House of Representatives, I think. But it's very clear that they're taking cases even when they don't have to, sometimes even without the apparent agreement of the 5th conservative, Justice Kennedy. Last year we had the affirmative action case. By the time it was decided, it was pretty clear he didn't really want that case and certainly didn't want to do anything with it. They ended up doing almost nothing with it. And the Proposition 8 California same-sex marriage case, I've never seen a more unhappy man than Justice Kennedy sitting up there on the podium during the argument when he openly called for the writ to be dismissed in that case. He said it's not time for this court to be deciding this issue. So sometimes I think the other 4, since it only takes 4 to grant cert, kind of put Mr. Kennedy on the spot just to see maybe they can get him to come around and do something that they agree with, but very often he doesn't. In terms of the coming term, rather than just going through the entire list comprehensively, I thought I would just focus on what I think of as the more interesting cases. Other people might disagree, the bankruptcy bar, or the tax bar, or something, but the more interesting cases that will be argued this term, and then try to organize them a little bit thematically. I'll start with the question of race, how the government, whether and when the government can and cannot consider people's race and treat people differently because of their race. An issue that is kind of constantly recurring at the court. Three years ago, we had the parents involved case. This is the case in which school districts in Seattle and Louisville were voluntarily mixing people together, integrating their high schools because they thought this was a good idea educationally. That was held unconstitutional by the Supreme Court 5-4 on the theory that you should not be treating people differently because of their race, even in the service of the presumably laudable goal of integrating high schools. And that was the case in which the Chief Justice famously said that the way to end racial discrimination in this country is to stop discriminating on the basis of race. And there's clearly at least 4 of them there that are moving in the direction of kind of the so-called colorblind constitution, the idea that there should not be an ability on the part of the government to give out benefits, take other steps toward people based on their race in any circumstance. Justice Kennedy has a more nuanced position on that. He's certainly willing to support treating people differently based on race when there are compelling reasons to do so. For example, he provides the 5th vote to uphold affirmative action in the Fisher case last year. But it is a sort of churning issue in the court, and we have definitely moved further in the direction, and are moving in the direction of shutting down the ability of government to use race as a criterion. Just as a prelude to what's coming up, but there was the Fisher case last year. This was the University of Texas case, where the University of Texas used a kind of Rocky Grutter-style holistic admissions process for some small part of its student body, where race could be a plus factor along with many, many other factors. And the concern there was that maybe the court's actually going to overrule the University of Michigan case and say you can no longer do that. But Justice Kennedy clearly decided that was not where he was, and basically remanded the case. It was kind of a punt. The other case that raised this issue last term in an indirect way was the Shelby County Voting Rights Act case. Now that case involved Section 5 of the Voting Rights Act, which required some jurisdictions, not others, to have all their changes of their election laws pre-cleared by the federal government. It's been around since 1965. And the official rationale of the case from the 5 judges who said it was unconstitutional was that this was a violation of some principle of equal state sovereignty, that somehow we shouldn't be treating some states differently from others, at least by using criteria based on the conditions on the ground in those states back in 1964, that the criteria have to be more up to date before you can even begin to think about imposing much greater burdens on some states than others. But what I think was really going on in that case behind the scenes was an antipathy to the Voting Rights Act that has its roots in the same movement toward a colorblind constitution that I was talking about. The feeling that the problem with the Voting Rights Act is that it requires you to treat people differently based on their race in order to try to achieve greater equality of opportunity to elect candidates of choice, to greater openness of the political process. The Act, though, because of the way the process of doing that works, you can't simply ignore race and pretend it's not there. The Act affirmatively requires jurisdictions and courts to draw districts on purpose to create opportunities for people to exercise their voting rights. And I think there are members of the court who find that whole concept disturbing. And so while they took a shot at one part of the Voting Rights Act, there are other important parts of the Voting Rights Act left that still require you to take race into account in order to make sure that people's voting rights are protected. But this march toward a colorblind constitution may continue as at least these same 5 justices are around, and we may see other parts of the Act stalled as time goes on. Now, just continuing this theme, though, of trying to decide decide what amount of consideration of race is allowed. Coming up, we have two cases. One is the case from Michigan, where the people of Michigan, in the wake of the University of Michigan affirmative action decisions, passed an initiative which bans affirmative action in Michigan for college admissions, for hiring of public employees or public contracting. And this ban itself was then challenged as unconstitutional. And the case is called Chouette versus Coalition to Defend Affirmative Action. Although some people have told me it's actually pronounced Shooty, I don't actually know, but maybe people actually from the Sixth Circuit might know, or you guys live in that circuit together. He's the Attorney General of Michigan. The constitutional challenge against this ban on affirmative action is based on a series of cases going back to Hunter versus Erickson, a case called Washington versus Seattle School District. And basically they are cases that say if you pass some measure which makes it difficult for one group of people to achieve their objectives in the political process, you're essentially putting them in a different position from everybody else. And that can be itself discriminatory based on race. And so the theory of the majority of the Sixth Circuit was that this is unconstitutional. And the gist of the argument is that you draw a comparison between a student that was trying to persuade the University of Michigan to give greater credit to children of alumni. And they then list all the various ways in which you could go about that. You could go talk to the admissions office, you could talk to the president of the university, you could talk to the board of trustees, or you could try to pass a constitutional amendment to require that in the state constitution. But you have lots and lots of options. But after this referendum was passed, instead of trying to increase the benefit of being an alumni child, you're trying to increase the amount that being an underrepresented racial minority is countered in the admissions process. You only have one option now. You only can try to amend the Constitution again by getting the signatures, putting it on the ballot, getting 51% of the people of Michigan to support it. So the Sixth Circuit has held was a classic example of, for that one group of people achieving that one central objective, making it much more difficult for them to access the political process and pass their initiative and get their objective met than anything else. Another case in which this argument prevailed was called Romer versus Evans. It's involving the famous Colorado Amendment 2, which basically said all measures that protect gay people as gay people from discrimination, state or local, in the state of Colorado, are hereby both repealed and prevented going forward. And Justice Kennedy, in that opinion, said here again, you're essentially taking one group of people and fencing them out of the political process. They can't just use the normal levers of democracy to achieve their objectives. The dissents in the Sixth Circuit, there were quite a few, it was a very close en banc case, said this is different from all those other cases. This is not about preventing people from passing the Fair Housing Act or achieving some other objective like that. This is repealing laws which are already themselves presumptively unconstitutional. These are law, after all, after Bruder, they say, in the dissents, any differentiation of applications based on the race of the applicant is presumptively unconstitutional. Maybe it's okay under Bruder, you find that there's no other alternative and it can satisfy strict scrutiny as a means of achieving diversity in your student body, but it's presumptively unconstitutional. And given that, they said the state of Michigan and the people of Michigan ought to be able to decide we don't want to try to do that. We're just not going to do it. That this ought to at least be an option for states, that affirmative action in admissions and in other places, with the cases focusing on admissions, should not be an obligation that states have to do or can never stop doing once they start doing it. That those are matters that the democratic processes ought to be able to handle. And if the voters want to put it in the Constitution that we're not going to do that anymore, so be it. So it'll be very interesting to see how this case comes out. Justice Scalia and the other real court conservatives clearly hate this whole idea of fencing people out of the political process as a theory. There is a quite remarkably vituperative dissent in the Romer case by Justice Scalia, which I'm sure many of you read, which just says this doesn't make any sense. The question is whether there's a fifth vote. Justice Kennedy, after all, wrote Romer. Roma versus Evans. So he may be more open to this theory, although he too is obviously quite sensitive about the use of race, identifying people, treating people differently based on race. Somewhat more open to it than the other four, but still sensitive to it. And so he's put in a very interesting posture where his sort of concern about too much consideration of race is put up against his prior decision in Roma about how sometimes you just can't fence one group out of the political process. And I've long ago given up trying to predict Justice Kennedy in many situations. He's a very interesting, complicated man, and does many good things and many terrible things in my view. So we'll have to just wait and see how that goes. Clearly, we may end up, though, with a situation where in Michigan, affirmative action is no longer there, and I would think that if that is upheld, we'll start to see such initiatives being pushed even more around the country. The other case this coming term that raises the question of whether government can treat people differently because of their race is the Mount Holly, New Jersey disparate impact housing discrimination case. Under the Fair Housing Act, which has been passed in the 60s, it is obviously illegal to discriminate based on race in provision of housing. And the claim that is made in this case is that a particular kind of slum clearance program of the town of Mount Holly violated the act because most of the residents of this area where the people were forced to move and relocate were from a protected minority, black or Hispanic. And the theory is that not that the town of Mount Holly did this in order to hurt people because of their race, based on intentional disparate treatment, but that it had a disparate impact. And so this raises the question of whether or not disparate impact theory, which doesn't require a showing of intentional discrimination, is available under the Fair Housing Act. It has been held since very early in the 1970s in dozens of cases that you can use a disparate impact theory under the Fair Housing Act. But there isn't any language in the Act that really supports that directly. And the comparable language in Title VII, the employment case, is very explicit. And so the contrast is actually fairly striking. And so the court may very well decide as a matter of statutory construction that all these cases have been wrong going back 30, 40 years, that there is no disparate impact theory under the Fair Housing Act. But lurking in the background is the constitutional question. The question of whether disparate impact theory, because it requires potential defendants, whether they're towns or employers or whatever, to treat people differently, to think about people's race in taking actions and deciding and take into account what is the impact of this action that I'm about to take on people, and does it have a differential impact on my black employees and my white employees, or on my black residents versus our white residents, or one neighborhood versus another identified based on race? Is that itself unconstitutional? And Justice Scalia wrote an opinion, a concurring opinion in a case called Ritchie versus DiStefano, the New Haven, Connecticut police case, employment discrimination case, in which he said it's lurking in the background and we can't ignore this issue forever. He certainly believed it is unconstitutional because it requires people to be motivated to take actions based on the race of the people that they're impacting. And to constantly be thinking about race in all of the actions that they take effectively requires you to have a racial intent in some weird way, when otherwise you wouldn't even be thinking about race. You'd be worried about getting the slum cleared out of your town, or closing this factory rather than this factory because this factory has more black workers and this black factory doesn't have more black workers. Those kinds of considerations. And so while I expect they will probably decide the case on statutory grounds, the constitutional issue is lurking there. This is all part of a piece of this broader enterprise of trying to look through all of the places in the law where people are allowed to or required to treat people as groups differently based on their race, and look for opportunities to clear it out, led by Justice Scalia and by the Chief Justice. So that's one whole theme to be watching for as we go forward here. Another one is First Amendment. Lots of interesting First Amendment cases coming up this term. The two big speech cases. One, the continued discussion of campaign finance and whether it's constitutional to go on at the Supreme Court this year. Citizens United may seem like a small case to get done with this one. In McCutcheon versus Federal Election Commission, we have a constitutional challenge to the provision of the Federal Election Campaign Act that limits the total amount that you can give as an individual to all candidates in campaigns and committees and parties and things like that in any biennial period. And the challenge comes from the guy who said, look, I'm happy to limit my contributions to each of these candidates to the amount that we're allowed to give to that candidate. But I want to give to more candidates. I can only give to 18 or 19 members of Congress. And I want to do more. And why in the world should I not be allowed to do that? And the law was upheld by a 3-judge district court in D.C. On the theory that the aggregate limits serve to buttress these individual limits. The individual limits are justified because the theory is if you give too much money to any one person, there's going to be the appearance of corruption or actual corruption. Too much money for to avoid quid pro quos. And the theory of the aggregate limits is that if you don't have them, then it will be too easy to evade the discrete candidate by candidate limits. Essentially, you'll give lots and lots of money to these various party committees, and they'll be able to funnel it all to one person. And you'll end up having given effectively $55,000, $75,000 to that one candidate, and he'll know where it came from, and you'll have basically avoided the limit which is supposed to prevent quid pro quo corruption or appearance of corruption. It's very interesting that the court is taking this seriously. But what it really raises is that ultimately whether or not the court is going to start to abandon the most important distinction in all the jurisprudence in this area, which is the distinction between expenditure limitations and contribution limitations. This is a contribution limitation. And the court has long, since Buckley versus Vallejo, drawn an important distinction between those two and said, expenditures, if you want to buy ads, if you want to, for yourself or somebody else, you're speaking. It's effectively exactly the same as speaking. We're not going to allow much regulation of that at all. But contributions to a candidate, those are things where there's a much greater danger of a quid pro quo or appearance of corruption, and we're going to allow pretty severe limitations on those. And so that's the regime we've lived under for decades now. It's produced some weird outcomes, which is effectively no regulation of really rich people running for office and spending all their own money, while their opponent can only raise money in small chunks from lots and lots of people. Various laws in which jurisdictions have tried to sort of compensate for that by allowing the non-rich person to have greater amounts of money that they can raise per person or compensate for the rich person. They've all been thrown out by the Supreme Court as effectively somehow punishing the rich person for his expenditures and his speech. So that's been going on. But basically what we have not seen is any movement yet to say we're going to start according full constitutional protections to your ability to contribute, as if that was the same thing as speech as well. So if they now say that the aggregate limits are unconstitutional, that will kind of breach the line. And I would think becomes very difficult to see a stopping point at that point, because if the aggregate limit is unconstitutional, why should the $5,000 individual limit be okay? And then pretty soon, there's a real danger, I think, that we unravel to the point where there is no limitation on what you can give to political candidates that is allowed under the First Amendment. And the only thing that the court has said would still be left is disclosure requirements. The sort of idea that you're required to disclose everything you've given to everybody, and somehow that will prevent you from, that would be a kind of a sanitizer that prevents the corruption from happening because people will be watching, et cetera, et cetera. Of course, we actually don't have laws that require much in the way of disclosure on a lot of stuff these days. And the Republicans have been staunchly opposing that since Citizens United said you could do it. So we may not have that either. The other thing that happened with Citizens United was Justice Thomas said even disclosure requirements are unconstitutional. So we are not moving in a direction where there's going to be much left in the way of regulation of campaign finance, at least if this McCutcheon case has as big a potential impact as I think it might. Sometimes things fizzle out. I would be quite worried that we're moving quite quickly toward further and further and further deregulation of speech. It's part of the politicization of the court, at least the perception of the court being, ever since the sort of Bush v. Gore, there's been this sort of feeling that the court is thinking a little bit too much about the political impact of everything it does. And this campaign finance area is really a classic example of it. And I think it's very worrisome for the court as well as ultimately for the country. So keep an eye out for that one. The other big speech case is McCullen versus Coakley. Now, this is actually a fairly narrow speech case, but it's really interesting. The issue there is there's a Massachusetts law that was passed that bars anyone from being within 35 feet of an abortion clinic. Now, there are exceptions, but the general rule is you simply cannot go in that. Obviously, if you're a woman going into one to get services, you're allowed to go in there. The other group of people that are allowed to go in there is people who work in a clinic doing their job. And so the purpose, obviously, is to protect people from harassment and from having the right to access these services being suppressed. The law was challenged by a group of pro-life activists who say, we don't harass people, but what we like to do actually is approach people very respectfully and engage them in conversations about what the alternatives are to abortions. And their view, they say, is that many women access these services without a great deal of understanding of those alternatives, sometimes under pressure from other people in their lives, that they haven't had a chance to think it through. And they claim that they've had a number of successful diversions of people to alternatives to abortion up in Massachusetts. And they want to continue doing that, but that this 35-foot ban prevents them from doing that because they simply can't get close enough to people to have a civil conversation. They're required to stand across the street with a sign and yell at them, which they say, you know, you can get a message out there, but it doesn't have the same potential effect of actually engaging somebody in a give and take. And so the law was challenged facially and as applied. The facial attack was based on these exceptions, the fact that clinic employees are allowed to come out, meet people within the 35-foot buffer zone, and basically put their arm around them and say, ignore those people over there with their stupid signs and come on in and we'll be happy to help you. And effectively, the argument is that you have a content-based distinction based on who can actually approach these people and talk to them face-to-face. The clinic people can, the anti-clinic people can't. And the as-applied challenge adds to that the fact that in the particular circumstances where the clinics are in Boston and Worcester and Springfield, the 35-foot zone ends up fencing them off even much further than 35 feet because it ends up, that line is out in the middle of the street, and so you have to stand across the street with traffic going by, and it makes it even more difficult to have a real meaningful exchange of views. The First Circuit threw out all of that and said it's just a content neutral, time, place, and manner restriction. You're not prevented from expressing your point of view. You can stand there with all your signs and express the view that abortion is evil, and people will hear you, and you don't have a right to the optimum method of communicating those particular views that you would like, that is simply appropriate for the legitimate interest of protecting people's right to choose to create this buffer zone. The case that the First Circuit relied on was a case called Hill versus Colorado, in which the court addressed, this is a Supreme Court case some years back, addressed a slightly different law. It didn't have a exclusion zone. It simply said that if you're in a zone, a buffer zone around any healthcare facility, it wasn't limited just to abortion clinics, you can't approach any person and engage them in conversation closer than 8 feet unless they've consented. And the court did say that was constitutional, that in that sensitive area, it was appropriate to have a non-content-based limitation on non-consensual conversation closer than 8 feet, that people should have a little bit of space and they can decide for themselves if they want to get into a more intimate conversation with other people in that zone. The plaintiffs in this case say the First Circuit was wrong in applying that principle to the Massachusetts total exclusion zone, because the Massachusetts law is different in two ways. First of all, it applies only to abortion clinics, not to all healthcare facilities, so it clearly is designed solely for the issue of pro or anti-abortion speech. And it is, of course, a complete exclusion, and therefore they have a much different ability to sort of, they can't even ask people, would you like to have a conversation with me? They can't, they have to stay so completely outside of the zone. I have no idea what's going to happen in this case, but the fact that it was granted sometimes is an indication that maybe the court is skeptical of the decision below. That's not really a good indication here, though, because one of the main arguments that the plaintiffs made was that the case, the First Circuit's decision upholding the law conflicted with a Ninth Circuit decision in which a panel had thrown out an enforcement policy in the city of Oakland. This was a policy that basically said if you're in the vicinity, if you're a police officer and you're in the vicinity of an abortion clinic, you basically shouldn't hassle the people that are supporting the women trying to get into the clinic. You should only hassle the people that are trying to prevent them from getting into the clinic. It was very sort of explicitly content-based distinction in terms of enforcement policy in that setting. And the Ninth Circuit panel, which I think was like Reinhardt and Berzon, it was not a sort of conservative panel by any means, said this is obviously a violation of the First Amendment. So the conflict suggests it's hard to read tea leaves in terms of where the court is going on this one. And so I guess we'll just have to wait and see. The third First Amendment case is not a speech case. It is a very interesting Establishment Clause case, raising the issue of legislative prayer, an issue that the court has not addressed for many, many years, since an old case called Marsh versus Chambers upheld the practice of the Nebraska legislature of having a pastor read a prayer, not a pastor read it, but any person read a prayer at the beginning. I guess it was actually a legislative chaplain they had that read prayer at the beginning of the sessions. In that old case, the court had pointed out that the first Congress, which passed the First Amendment, had a paid chaplain and had prayer before each of its sessions. And so the court said, hard to see how the First Amendment could be interpreted as preventing that practice. And so the world has gone on with that principle in place. The town of Greece, New York, G-R-E-E-C-E, Greece, New York, had a town council meeting monthly, and they decided they were going to have a prayer before each of their sessions. And they went on for a number of years having people from the local churches giving prayers. And they were all churches. So every single one of these prayers for a number of years was a Christian-focused prayer. And they were not shy about it, apparently. Lots and lots of Jesus our Savior, et cetera, in the prayers. So some local citizens said, we really shouldn't be having this at all of our town meetings. They brought a lawsuit. The town of Greece lawyers decided, well, we're going to diversify things for a while. And so for the first year after the lawsuit was filed, we had a local Jewish guy give a couple of prayers, somebody from the Baha'i faith, and a Wiccan. And so they made that record, and then after the record was closed, they went back to having all the local ministers and priests give the prayers. That apparently was just a one-year diversion from their policy. But their answer is, look, we'll let anybody give the prayer. You just have to volunteer. They didn't actually tell anybody that over these years, but that is their answer. And so the prayer policy of the town of Greece was upheld by the district court, but the Second Circuit, in an opinion that's very kind of hard to interpret, said this went too far. And they said, look, we understand that legislative prayer is okay. We're not even saying that sectarian prayer is always bad. It can't be that it's an automatic violation of the Establishment Clause because some ministers happens to refer to Jesus our Savior. In fact, it would be a problem if the town started to try to edit the text of the prayer in advance, that itself would be an Establishment Clause problem, a sort of entanglement problem. And so that's not what we're saying, but they understand. What we are saying is that over a period of years, you give the impression, intentionally or unintentionally, that the town of Greece considers some religious beliefs superior to others. And simply, those are the beliefs that are always being featured, and there's never any statement that says the text of this prayer is not the official belief of the town of Greece or anything like that. convey too much of a message of preferred beliefs and unpreferred beliefs, and that just goes too far. The cert petition that challenged this said, look, it was completely, anybody could volunteer, they've had Wiccans, this is Marsh versus Chambers, and what do we do about the fact that this is really no different from the first Congress? And so the fact that the court took the case, I think, is interesting. There is a Establishment Clause law is a bit of a mess here in terms of how they should judge this. There's sort of two competing theories in this situation. Well, is there sort of you have to prove actual coercion of people to participate in this thing, or is it enough that it's just sort of an apparent endorsement of Christian dogma by the town? And what do we do with this historical record? We filed an amicus brief saying, well, even if coercion is required, you shouldn't just assume that a town meeting is the same as a state legislative session with a gallery up on the side. When you're at a town meeting, you're in a small room, the town leaders are sitting there looking at you, you're with your neighbors and friends sitting here, and when the minister stands up and says, let's all stand up and bow our heads, you're going to stand up and bow your head if you know what's good for you in terms of trying to get that zoning variance passed that you're trying to do in 2 weeks. It is a very much more collective experience with lots of peer pressure and pressure vis-a-vis the town council to participate and at least give the appearance of participating in a religious ritual. And so this was a brief we filed on behalf of a bunch of political scientists. And so I don't know whether that would be influential or not, but I do think that there might well be a distinction drawn between that kind of setting and the gallery of Congress or the gallery of a state legislature where you can sit up there and talk about baseball if you want to during the prayer. There's no requirement that you participate or even acknowledge what's going on down there. And you're certainly not part of the gathering that is praying in the same way. Changing gears fairly substantially, one of the other huge cases this term is the Congress, in the usual functional way, was not interested in actually confirming anybody to these positions. And so he did that. They figured it was a recess because Congress, the Senate had gone out of session on January 3rd and said, we will not be doing any business until January 23rd. And then subsequently, the NLRB with these 5 members rules against Noel Canning on about some I didn't actually know what it was about, some unfair labor practice. And they go take an appeal up to the D.C. Circuit challenging the NLRB and basically saying the NLRB shouldn't be treated as having 5 members because those 3 people were not properly appointed under the Recess Appointments Clause. And the D.C. Circuit agreed in a very, very broad opinion, broader, I think, than they had to go by some measure. First, there are 3 issues that are there, and the D.C. Circuit addressed the first 2. One is, what's a recess? And the D.C. Circuit has said now that a recess of the kind that we had there, where the Senate has been sworn in, but it has gone away for 3 weeks, and is not coming back by unanimous consent, is not a recess for purposes of the Recess Appointments Clause. The only recess that counts is the one between the last action of the last Senate and the first action of the next Senate. So it only happens every 2 years for a brief period, a week or 2 or 3, whatever that amount of time is. That's the only real recess. The second question is what vacancies are covered. And the D.C. Circuit said the only vacancies that can be filled by recess appointments are those vacancies which originate during that short recess. If there's already been a vacancy during the last Congress, and that vacancy continues into that recess between the 2 sessions, you can't fill that one. And they made these both of these rulings sort of based on a very close reading of the text of the Constitution, somewhat ignoring the history of this idea that you have to the vacancy has to originate during the recess contradicts the practice of presidents going back to 1820, and is certainly not compelled by the language of the Constitution, I would say. The third issue was the one that they didn't even need to address. During this 3-week session, when the Senate had decided it wasn't going to do any business until January 23rd, they nevertheless had one senator come in and call them into session every 3 days. The purpose of that was to prevent the president from being able to call it a recess. And they would gavel them in. No other senators were required to be there, and then they would gavel them out. And they did it every 3 days because for some reason, 3 days is considered an adjournment rather than recess. And so there's a third issue in the case, which is even if the recess would otherwise be okay, and even if the vacancies would otherwise be covered, if does this little pro forma every 3 days calling into session and then gaveling them out do the job in a situation when there's an official vote that's already been taken by the Senate, the party left town that said no business will be conducted until January 23rd. You can all stay home. It was not a surprise that the Supreme Court took the case. Let's just say that because it raises all sorts of complicated questions of the balance of power between the executive branch and the legislative branch. It also raises fascinating issues of remedy, because what the D.C. Circuit did was it threw out the NLRB order that applied to Noel Canning, saying that they didn't have any quorum to do business. Presumably, everything that the NLRB has done since January of 2012 is equally void, which is kind of hard to unscramble. And there are other potential things that might come into question. For example, do you know that Chief Justice Warren and Justice Brennan and Justice Stewart were all recess appointees? And none of those appointments would have qualified under the standards of the D.C. Circuit. So maybe there's all sorts of Supreme Court decisions from the 1950s which are void and can be ignored. I mean, they were all eventually confirmed, so they became. But there was a practice. President Eisenhower followed of appointing judges through recess appointments, and lower court judges have been appointed more recently through recess appointments. A practice I always thought was very bizarre, considering this under Article 3, you need to have life tenure before you should be able to cast a vote as a federal judge. But nevertheless, that's how it's been done. And here again, I think what we have is a case that really the court ought to be very careful about what the perception will be of them politicizing themselves. The theories that the D.C. Circuit adopted are so sort of extreme in terms of trying to ignore historic practice. It can't help, I think, to be interpreted as sort of a response to a particular president at a particular time. And after the healthcare case, it is, I think, a time when the court ought to be very careful. And obviously, Chief Justice Roberts in the healthcare case understood that to some extent and found a way to avoid what would have been sort of a nuclear war between the president and the court. But this is another example, I think, where they ought to be very careful about meddling and making up rules after the fact based simply on a one-sentence clause of the Constitution that will be perceived, and perhaps correctly, as motivated by who happened to have won the last 2 presidential elections. I think it's really a dangerous thing. Then we move on to yet another really interesting case, even though it involves the treaty power. Bond versus United States. Now, Bond versus United States involves a very funny little story. A woman found out that her best friend was pregnant, congratulated her, found out that her husband was the father, and was less happy. She had access to some rather severely poisonous chemicals, which she then spread around the premises of her friend, the pregnant woman, in the hopes that she would poison herself. And there was a minor thumb burn caused, apparently. But she was not charged with attempted murder or anything like that. She was charged by federal authorities with violating the Chemical Weapons Convention Implementation Act of 1998. In other words, for being engaging in use of weapons of mass destruction in violation of Chemical Weapons Convention, sort of like Syria. The argument was made that this is really a crazy use of this act, and it was never intended to be used in this way. And if it is used this way, it exceeds the power of Congress. This is simply regulating local, run-of-the-mill crime. It has nothing to do with the power of Congress. The government's response is that the law clearly implements the treaty. The treaty is unquestionably, in effect, was ratified by the Senate, and there is no limit on the power of Congress to do what it wants to do implementing treaties under the treaty power. there is some dictum to that effect in an old Supreme Court case. But this is, so far the government's won the case, but the court did take it. And it has all these interesting echoes of the healthcare case, because what it means is effectively there are in whole areas of the law no limit at all on what Congress can do in regulating what looks like just sort of police power, regulating interpersonal behavior of people that has nothing to do with any federal interest. To sort of round out the story, in the Supreme Court, not only are they defending it on the ground that it is implementing the treaty, they're also defending it on the ground that they have the commerce power being exercised here as well, that somehow because they're regulating the use of chemicals to hurt people, this will affect the market and interstate market of chemicals, and therefore the commerce power, they should be able to prohibit this action of this woman as well. And so that's when it really has echoes in the healthcare case, where the main argument that was accepted by 5 justices, the problem with the individual mandate, they said, was if you accept the proposition that the federal government can, and the commerce power, require you to engage in commerce, or require you to do something you're not doing, then there is no effective limit on the power of Congress to exercise the police power, that there will always be a way in which they can do whatever they want and call it commerce power. And so we have Paul Clement arguing for Mrs. Bond, citing the National Federation of Independent Businesses case back in the Supreme Court, saying, we're back here again. There is again Congress is asserting power to regulate local affairs in a way that has no limit and will effectively change the entire balance of power under the Constitution. So keep an eye on that. My guess is she's going to win. And then finally, the Fernandez case is an interesting Fourth Amendment case. So here's the Fernandez case. There are 2 people living in this house, man and woman. He's clearly the guy that they're after. They come to search the house. He says, no, you can't come in here. I know my rights. They say, you're under arrest, because they have enough evidence against him already. They take him off to the jailhouse. Then they come back to the house and they want to search him, get more evidence. Who's left? The woman of the house is there. And she says, okay with me. And so the question is, does his assertion of Fourth Amendment right not to have his house searched without a warrant persist when he's no longer on the premises, and specifically when he's no longer on the premises due to the action of the government itself? The lower courts have held that you have to still be there to continue to assert your Fourth Amendment right. You can't just assert it once and it lasts forever. So we'll have to watch that one as well. It's kind of one of those law school textbook kind of Fourth Amendment cases that you'll probably be reading about in the future. There was also upcoming, I think most people think one of these will get granted this year, a case about cell phones, which is something that will get a lot more people interested in than this who I just told you about, which is if you're arrested for anything, they can search your wallet, they can search your pockets. Can they search the contents of your cell phone? The contents of your smartphone nowadays, of course, are virtually everything in your entire life. Every document, every message, every communication. Is that entirely available to the government because you've been arrested in the way that the contents of your pockets previously have been? I think the court is quite sensitive nowadays to the need to adjust the Fourth Amendment to modern realities, the modern technological realities. We had the GPS case a couple of years ago when, quite surprisingly, the court said, the Fourth Amendment violation from having this GPS tell where you've been in your car, even though all the prior law said that you have no privacy interest in where you're driving around on public streets, you could be observed. And the court said ultimately, yeah, if the computer records it for months at a time, that's a very different thing. And so they obviously are sensitive to the issues of technology and what that can do. And in that case, Justice Sotomayor wrote an opinion in which she talked about another issue, which is the potential need to adjust the rule that says information about you that's in the hands of third parties is never protected under the Fourth Amendment. Here she was referring specifically to the fact that the telephone companies have all that information that's also in your smartphone sitting in their computers. and probably a lot more information about you too, like everywhere you've ever surfed the web or whatever. And there is this lurking concern out there that people are going to these telephone companies and getting all that information. She said that, of course, well before Mr. Snowden revealed that they actually are doing that, at least with respect to metadata from the telephones that are being used. And so this is a kind of an interesting series of things that are moving in the court's direction, and it'll be interesting to see how the court responds. They actually have cases pending now on this, the Snowden revelations in particular. One group actually said, look, we can't file a case in federal district court. They won't have jurisdiction to challenge that. We can't file anything in the Foreign Intelligence Surveillance Act, court either, because we don't have a role in that. There's only two parties. There's a government and a telephone company, whoever they're trying to get the information from. So they filed a direct petition in the Supreme Court saying, you are the only court in the country that can vindicate our rights. And they said every single person in the United States has a problem with this because your metadata has been bulk collected by NSA. So there is a huge, massive violation. And it's pretty difficult to suggest that the statute authorizes this. It says it has to be relevant to an investigation. The government's argument is that anything we collect is potentially relevant to an investigation because if we need it, we'll go find it, it'll be relevant. So it's not, the argument against that program is pretty strong. The difficulty is figuring out what to do about it legally. And so it'll be interesting to see what the court does with this direct petition in its original jurisdiction to do something about that. Probably not very much. But the government is worried about it enough that they keep asking for an extension of time to respond. They haven't actually said anything yet about what they think about that thing. So I will take some questions. But I thought I would, if there was a little time, talk about where we're going on gay marriage. I was fortunate enough after the Lawrence case 10 years ago to be very involved in the decisions to challenge the Defense of Marriage Act. And in the first case challenging it, which was up in Massachusetts, the Gill case, which successfully challenged the Defense of Marriage Act. And just, I think, in an ACS meeting, anybody who doesn't know what the Defense of Marriage Act is, shame on you, but the Defense of Marriage Act said you can be married in your state, but if you happen to both be the same gender, you're not married. You're nothing to us, federal government. Your marriage means nothing for any federal purpose. Social Security, tax returns, thousands of other things. And in the wake of the Lawrence case saying that you can't put people in jail for being gay, the question was, when do we want to go back to the Supreme Court, and how soon, and what's the right case to do that? And the consensus was not too soon. There was a period of time in there when the gay rights movement was blamed for losing the presidential election in 2004 because of the fact that they put dozens of these referenda on the ballots in all over the country, including Ohio, which was a very close and decisive state in that election. So people were a little gun-shy about that, and they weren't altogether sure what Justice Kennedy and Justice O'Connor wanted to do beyond protecting people from being dragged off to jail in the middle of the night from their houses, which is what Lawrence was about. But eventually it became, as more and more people started to get married in Massachusetts and other states, became clear that the Defense of Marriage Act was the place to go. First of all, it was just incredibly offensive. You have these people actually married under their own state's laws and have succeeded in persuading their state to marry them, and they still can't be treated as married by their own federal government. So you end up, as Justice Ginsburg famously put it last spring, with skin milk marriage. It's a sort of half-married status. It also was incredibly stupid as a law because it didn't accomplish anything. It didn't save the federal government money. The arguments to try to justify this as sort of protecting children because we think that they're better off in heterosexual marriages and everything don't make any sense because these are people who are already married with children. Denying them Social Security benefits doesn't do anything for their children. It got to the point last year when the case was finally in the Supreme Court that Paul Clement had to come up with arguments that were so bizarre to try to justify this law. The argument that he made was that the reason we are not recognizing same-sex marriages is because if the federal government recognizes them, that will somehow change the perception of the institution of marriage on the part of straight people. And the real problem is straight people, is straight people have pregnancies that are unexpected. And we really want those people to be careful about that and get married when they do. And if we cheapen the institution of marriage, we'll end up with more people or children of straight people who have no unmarried parents. So in order to solve that problem, we're going to continue to disrespect the marriages, actual marriages of gay people and hurt their children. That was the argument that was being made. And, you know, I can't say that the Supreme Court took it very seriously, but nevertheless. So we brought that case. It turned out to be exactly as everybody else predicted. Justice Kennedy wrote a 5-4 decision. We had this other little case that arose in California, sort of outside the, that was not the plan. That was Hollywood's plan, the Proposition 8 case. And had us all quite a bit worried that that was a few years ahead of its time. The court agreed that it was a few years ahead of its time, but at least they didn't issue an opinion rejecting marriage equality. They simply ducked the issue by saying there was no standing appeal. So what's happening now? Well, lawsuits are being filed all over the place in federal court for marriage equality because basically the message that Justice Kennedy sent, I think most people would say, is that if you make me vote on this, I'm the fifth vote. The opinion is quite eloquent about the dignity and disrespect that's visited on these people. And it almost has a place at the beginning where it talks about how the idea of marriage of same-sex couples was very strange and novel some years back, and then it became more understood, and it became more accepted, and became more popular, and now it's adopted in 14 states. It was almost as if Justice Kennedy was sort of describing his own mental evolution on this issue over the last decade or so, and I think it became clear that he understands that same-sex couples have the same right to be treated equally as everybody else. And so the result of that is everybody's figured out we want to be the next case, and and we don't really care whether we're filing in a circuit where we're not likely to win at the circuit level. So we have cases being filed in 10th Circuit, 11th Circuit, all over the place, and all being filed in federal court. The original strategy had been to file marriage cases in state court and do them under the state constitution and avoid federal review, but no more. Now we're back heading toward the Supreme Court. And in fact, there's a case that's being briefed already in the 9th Circuit. Nevada and Hawaii cases are going to be argued by the end of the year, and so we could actually have this issue back before the court within a year after that. And I think if the 9th Circuit were to hold that there is a broad right to marriage equality, the Supreme Court would almost have to take it because it's a huge circuit. And that's to have that rule prevailing as a matter of federal constitutional law in that circuit, and have these other cases come percolating up. I think it would almost be hard to allow that to happen. So there are people that think, oh, it's going to be a decade, it's going to be a decade. I think it's 2 or 3 years until the Supreme Court has to face up to the question of marriage equality. Won't have a way to avoid it. I think even friendly defendants in states that want the plaintiffs to win are going to figure out they always file an appeal this time so that there is a jurisdiction to decide the issue. That was the problem in the Prop 8 case. Not only that they didn't defend the law in California, but that they didn't appeal. So the only appellants were these proponents of the measure. So those people who think that this issue is a long-term proposition, it's not my view. I think that the way this is working is we will have a decision of the Supreme Court on this issue by 2015 or 2016, and hopefully that people are reading the tea leaves correctly, at least from my point of view. Hopefully that marriage equality will prevail. It would be better, I suppose, if it was not 5-4, but better 5-4 than 4-5. So with that, why don't I take some questions? All right.
So I have a question about the Fair Housing Rights Act you talked about and the slum clearance case. And I wonder if you have a sense about the shadow that Kelo casts over this decision and whether there's anything lingering about the government's right to engage in this kind of eminent domain practice in the first instance that might color or affect the outcome.
I haven't thought about that. The question was, since this is a slum clearance case, just a Kelo case about taking the property from slum clearance and basically taking people's property because it's they're trying to improve the economics of the town and doing so somehow lingering there. I doubt it's going to have much effect because they've already had this issue once before in another case coming out of St. Paul, Minnesota, which the St. Paul Democratic governor was convinced to settle it before they could decide the issue. There's already rumors that the Mount Holly government may be persuaded to settle the issue. So I think they think of this as an issue about race, not an issue about property. The other case was about tenants, and it was somewhat similar in that it had to do with, obviously, poor people and poorly maintained property in St. Paul. But I don't think they're going to see it this way. I think they're going to see it in terms of the colorblind constitution and one more step in that direction. Scared you all to death. Yes, sir.
On the gay marriage cases, what do you think the prevailing argument will be? Will it be a substantive due process, or will it be a full faith and credit? I mean, are there better arguments now than others?
The full faith and credit argument is not a very strong argument. The argument, which would be the argument that because I got married in New York and I've come back to Tennessee, Tennessee has to respect my marriage. Because marriage is not a judgment of a court, it's simply a status that is imposed on you. The full faith and credit clause has never been understood to impose the same kind of requirement of respect that, for example, an adoption judgment does, or other kinds of court judgments. And so states have long had the power to say we won't recognize other states' marriages if they violate our public policy. So some states allow first cousins to marry, other states won't treat those people as married. And so I don't think that's how this gets resolved. Ultimately, it has to get resolved as a matter of 14th Amendment law, whether it's equal protection or substantive due process, liberty clause. They're kind of the same argument in different forms. And I think they'll probably end up making both arguments in it. But finally, the nice clean argument is there ought to be heightened scrutiny of discrimination based on sexual orientation. If you look at the criteria by which gender and race and everything gets heightened scrutiny, it's like, is there a history of discrimination against this group? Are they politically powerful enough to protect themselves from discrimination? Is this a criterion which affects your ability to contribute to society? Those are the kinds of things you look at. And if you apply those factors straight up, as the federal government told the Supreme Court, the answer is obvious. And once you get into heightened scrutiny, then there's really no possible defense of refusing to treat same-sex couples the same as everybody else. And I think in the end, that's probably how it gets written. Kennedy has done 3 cases, Romer, Lawrence, and Windsor, where he's avoided altogether the issue of scrutiny. And it's not even clear in Windsor whether it's a due process case or equal protection case or a federalism case. He's kind of Delphic in a true sense. But maybe the fourth one, they'll finally just decide it flat out that treating people differently based on their sexual orientation is just the kind of discrimination that's never allowed. There's almost no other discrimination in the law now that is allowed. That people try. I mean, obviously employment discrimination comes up occasionally against public employers under the 14th Amendment, but not very much. So that's how I assume it'll come out.
I have a question, and it has to do with the Commerce Clause. And that is, we in Tennessee are experiencing a supermajority of Republicans, and it's a little different world here right now. But the world in D.C. is legislative versus a judicial. Who's going to come out on top on this Commerce Clause situation? And you alluded to it, that might come up in one of the opinions. But I think that there's a real conflict, a stewing about when will Congress kind of rear back and say, we get to pass the laws. And what they've done in the healthcare.
In the healthcare case, yeah.
God, I mean, if you really looked at what they did with the Commerce Clause and said, all these things you've been doing, we're saying you can't do anymore.
Well, just reflect a little bit more generally with the healthcare case. I think that the theory that they came up with that somehow this individual mandate goes way beyond anything we've ever done, and this is terrible, and we have to draw a line in the sand, is kind of nuts. I agree with that. But I actually don't think that the case guts the Congress's power to the Commerce Clause. They still upheld Wickard versus Filburn. Now, Wickard versus Filburn said you can prevent somebody from growing wheat in their garden to eat in their own house. Because if they, and the theory, this was from the 1930s, because if people grow food for domestic consumption, they will buy less in the market, and that will have an effect on interstate commerce. So there isn't, aside from, somehow they've just carved out mandates and said that's different everything else. Because apparently they're afraid they're going to be told they have to eat their broccoli or something. But I don't actually think that it hasn't, this mandate issue has never come up before in 200 years. So I don't actually think that the Commerce Clause holding by itself does very much to prevent Congress from exercising pretty broad powers. Obviously, they may not be able to regulate people trying to kill each other with poison in this case that's coming up here. But it actually, the other holding of that case that actually has greater potential impact, which was the validation of the requirement that the states continue to participate in the Medicaid program after the Medicaid program was enlarged to include lots and lots more people. The court said that was too coercive of the states, and that's had an immediate practical impact, which is that lots and lots of people in this country are not going to get covered under the Health Care Act for a long time because these governors are, I think for more political reasons than anything else, refusing to accept the money. And 90% of the money comes from the federal government. And they're talking about a whole sort of slice of people, the working poor, who have not had coverage for forever, basically, and they could get coverage for them, and they won't do it. And it's hard to tell how far that theory might be used, what's coercive and what's not coercive. There's no real standard that's applied there. It's just sort of like, when you see it, kind of a standard. And so in the wrong hands, that could become problematic for other laws that Congress passes to try to work with the states but impose requirements at the same time and how they use federal money.
Education.
Education is a classic example. And the argument is you're giving us too much money and it's too desirable. We can't turn it down. Therefore, you're forcing us to do something. It's really odd. And so, the answer ought to be, well, if you don't want the money, don't take the money. Be a big boy. You're a state. You're not just some poor person out there. You're the state, sovereign state. Exercise your own judgment. But that doctrine, I think, is actually, it's a practical matter, maybe more nefarious than the Commerce Clause does. So that's my view. We're wandering around constitutional law here.
All right, well, if that's it, please join me in thanking Paul for his fantastic